Dear friends, under the constitutional schemes of things, the core principle of the state organ is divided into three: legislature, executive, and the judiciary, and each has its own powers and responsibilities in its own domain and shall not interfere with one another. This is the separation of powers scheme, and it is the basic doctrine of the Indian Constitution as enshrined by the Kesananda Bharati case. But the President, under Article 143 of the Indian Constitution, has made 14 questions to the Supreme Court of India for giving its opinion, and the Supreme Court of India has heard the case at length and decided to answer all the 14 questions. The point here is that the President of India and the Government of India and the executive branch of the organ knows all these constitutional schemes under the separation of powers, but it has made this reference through the President of India instead of approaching the court of law as it deems fit, but either by review petition or curative petition after the defeat in the case of the Tamil Nadu versus Governor of Tamil Nadu in giving the powers to the governors and the timeline fixed by the uh, division bench of the Supreme Court of India on April 8th, 2025 of this year. The point here is that all the questions were given according to the concepts and principles based on the Indian Constitution, constitutional morality, and constitutional ethos and values that have been enshrined by the forefathers of the Indian Constitution during the Constituent Assembly debates. The first point is that whether the Supreme Court of India has the powers to fix timeline for the governors or the president to act upon the bills for giving its assent. The Supreme Court of India has said that there is no fixed timeline for the governors or president to act. And in the Constituent Assembly, there was a debate whether the governors ought to clear the bills within 2 weeks or 6 weeks. And Dr. B.R. Ambedkar, the chief architect of the Indian Constitution, has finally concluded that we should not intrude into the powers of the governor or the president, because the time would give that power to the authorities concerned to fix in such a way to the gubernatorial post, that is governors and the president of India, because of the powers vested with them. The point herein is that the Supreme Court of India has given its advisory opinion, that is the constitutional bench of the Supreme Court headed by B.R. Gawai has given the constitutional advisory opinion. It is not mandatory on the part of the government to take it as a verdict given by the Supreme Court of India as a final word or finality of the law of the land. It has not answered three questions I read out. That is, question number 12. In view of the provision of Article 145 within bracket 3, is it not mandatory for any bench of the court to first decide whether a case involves questions of law and has to be referred to a bench of 5 judges? Answer is returns unanswered, irrelevant to this reference. The point herein is that under Article 145 within 3, the power is vested with the Indian judiciary and its independence. the Supreme Court bench would decide whether it would be decided by a division bench or a constitutional bench. It is up to the domain of the Indian judiciary to decide the court. And the Supreme Court of India, though it is in its advisory opinion, has clear-cutly said that the question is irrelevant. As per the constitutional scheme, something under Article 145 within bracket 3, the court, that is the judiciary, is empowered to decide whether it is to be dealt by a division bench or a constitutional bench. Another question, 13, question number. Do the powers of the Supreme Court under Article 142 of the Constitution limited to matters of procedural law? The thing is that, is it based on a procedural law or substantial law? That was the primary question of the President of India as question number 13. And the Supreme Court that is constitutional bench, answered that not possible to answer in a definitive manner. Scope of Article 142 answered as part of earlier question. That is, under Article 142 of the Indian Constitution, the Indian judiciary has the power to review the laws made by the Constitution, that is the Parliament, and the laws made by the Parliament is subject to judicial review. Hence, under Article 142 of the Indian Constitution, and the cases are being dealt with, and if the aggrieved party, whether it is a private party or a government, state government or union government, may approach the court of law in an appropriate manner, but not asking questions like this. It may approach in a review petition or a curative petition if it is disagreed with the judgment of the case, but not through the precedent reference. This is the point. Another last question: does the Constitution bar the Supreme Court from revoking, that is, centers states disputes except by way of a suit under Article 131, irrelevant to the functional nature of the reference, hence written unanswered? Questions number 12, 13, 14 were unanswered and termed by the Supreme Court of India as irrelevant, because this constitution itself speaks about the things in a clear-cut and a categorical manner, and the original jurisdiction of the Supreme Court of India lies on Article 131. It can decide on matters between parties, between one state and another state, between more than one state and union government, and all the things would be decided only by the court of law. If the court of law decide, it is binding on all the high courts and government of India and all the state governments. This is the constitutional position. What is interesting to be noted herein is that the constitutional bench headed by the Justice B.R. Gawai has never questioned the April 8th, 2025 Tamil Nadu versus the case of Governor of Tamil Nadu, and has never questioned the judgment delivered by the division bench of the Supreme Court on Tamil Nadu case. Hence, the Constitution bench stood with the Constitution of India and stood with the case of the Tamil Nadu government in affording the spirit of the Constitution under the doctrine of separation of powers, and also under the basic structure doctrine of keeping all the things, that is center state relations, that is federalism and everything, to be intact and not touched by any authority. That is the message given by the Supreme Court of India. Hence, April 8, 2025, the case of Tamil Nadu holds good for all purposes. It is the law of the land, unless or otherwise it is challenged by a review petition or a quotation petition by the government of India. This is the message of this video. Thank you so much.